Welcome, everyone. I am so incredibly thrilled you're here. For those of you joining this explainer, I know you're highly motivated to master the actual mechanics of the law, not just, skim the surface. So consider this a self-contained, completely rigorous class. We're going to take a patient, meticulous approach today. We definitely won't be rushing. Instead, we're going to carefully build your understanding of how legal professionals communicate and operate right from the ground up, ensuring you walk away with real, actionable knowledge. Today, we are covering the rigorous mechanics of legal writing and the essential scope of paralegal practice, which together form the absolute foundational tools you must have to communicate, navigate, and enforce the law. Okay, let's dive into our roadmap. First up, Introduction to Legal Writing. 2. Characteristics of legal writing. 3. The legal writing process. 4. The paralegal role and boundaries. And finally, number 5. A comprehensive course recap. All right, let's kick things off with Section 1, Introduction to Legal Writing. Before we get into the nitty-gritty rules, we really have to understand how legal communication inherently differs from the ordinary writing you use in your daily life. Think of everyday writing kind of like painting a picture, right? You have the creative freedom to express your thoughts however you see fit. Legal writing, on the other hand, it's like building a massive load-bearing brick house. Every single brick must be a proven fact or a governing law. You cannot simply state an opinion. You assert absolutely nothing without a statute or a decided case backing it up. It is entirely dependent on mandatory authority. So, keeping that brick house analogy in mind, let's lock in the formal terminology. Legal writing is strictly defined as the application of legal analysis to written communication, whether that's for courts, clients, colleagues, or academic readers. It's not just typing out legal facts. It is the active, rigorous process of analyzing the law and communicating that exact analysis structurally. Now, believe it or not, we can actually categorize every single piece of legal writing in the world into a strict taxonomy of just 4 types. Let's walk through them step by step. First, we have academic or research writing. A concrete example here would be a doctoral dissertation or a case comment in a law review. Second, we have practical or practitioner writing. This is the day-to-day work of lawyers. Think of pleadings filed in court or a commercial contract between 2 giant businesses. Third is judicial writing, which comes directly from the bench, such as a judge's final judgment or a formal court order. And finally, legislative drafting. This is the actual writing of the laws themselves, like statutes, rules, or municipal bylaws. So again, that strict classification is academic, practical, judicial, and legislative. Moving right along to Section 2, Characteristics of Legal Writing. So, what specific, mandatory traits actually elevate a regular document into a legally sound one? Well, it all begins with the strict rule of clarity and precision. In legal writing, exact terms matter profoundly. Words are never just flavor text. Let me give you the absolute classic example, the words shall and may. In a contract, if it says a party shall deliver goods, that is a mandatory legal obligation. If it says a party may deliver goods, it's purely optional. The rule here is absolute. Exact terms in legal writing are never, ever interchangeable. But beyond just precision, a document needs an ironclad logical structure. You have to build your argument in a way that a judge or a client can easily, flawlessly follow. And this brilliantly illustrates the gold standard of structured legal argument, the IRAC method. Let's walk through these precise steps. First, I for issue. You clearly state the exact legal question at hand. Second, R for rule. You state the governing law or statute. Third, A for application. You meticulously apply that specific rule to the facts of your case. And finally, C for conclusion. Your definitive answer. Issue, rule, application, conclusion. It's a lifesaver. Furthermore, going back to our brick house analogy, you must show your absolute proof. You can't just casually say a rule exists. You have to point to exactly where it lives. This brings us to the formal definition of proper citation, the practice of tracing every single proposition back to its authoritative source. To do this, professionals use highly specific style guides. For example, Indian journals predominantly use the ILI style or the Blue Book, whereas UK-oriented work strictly relies on OSPLA. And remember, these aren't suggestions. These are required terminologies and frameworks for proving your work. Okay, Section 3, the legal writing process. Now that we know what legal writing looks like, how do we actually create it? Achieving that level of exact precision we just discussed requires a strict, unyielding methodology. You don't just sit down at a laptop and start typing away. The mechanical process flows through 6 very rigid steps. Step 1, understand the assignment. Step 2, conduct the research. Step 3, outline your argument, likely using that IRAC method we just learned. Step 4, draft the document. Step 5, edit in citation check. And Step 6, finalize. Now listen closely because I want to emphasize this forcefully. Most weak legal writing does not fail during the drafting stage. Nope. It fails precisely at Step 5. Editing and citation checking are not optional final glazes you just brush over a document. They are the rigorous stress tests where the actual legal validity of your document is secured. Let's pivot now to Section 4, the paralegal role and boundaries.
We are moving from the paper rules to the professional personnel who actually execute this vital work. Think of a paralegal as the essential architect working entirely behind the scenes of a major construction project. They are drawing up the blueprints, verifying the materials, and making absolutely sure the foundation is structurally sound, even though they aren't the ones standing on the stage cutting the ribbon at the end. They handle massive, load-bearing legal tasks, but they do not argue in court.
Let's look at the strict legal definition to ensure this uncompromising boundary is perfectly memorized. A paralegal is a trained non-lawyer who assists lawyers, but strictly cannot represent clients in court, nor can they give an independent legal opinion. To truly understand this boundary, we have to look at the statutory law that actually creates it. Consider the Advocates Act 1961 as our first landmark framework today. This act establishes a strict statutory rule regarding who can actually practice law in India. Under the Advocates Act, only an enrolled advocate is legally allowed to practice law, represent clients in court, and offer independent counsel. A paralegal, while highly trained and totally essential, is officially barred from independent practice. This statutory boundary matters immensely, folks, because it protects the public by ensuring only fully licensed advocates are representing them in the courtroom. So the crucial point is understanding what these highly trained professionals actually do all day within those boundaries. Typical tasks include legal research, drafting documentation, client intake, legal aid, court liaison support, and due diligence. Let's anchor this with a really concrete illustration from shipping law practice. Imagine a massive ship sale. A paralegal doesn't go to court for this. Instead, they handle the absolutely essential documentation for vessel arrest applications, they coordinate directly with P&I clubs, which are marine insurance mutuals, and they run the painstaking due diligence checklists during the entire sale and purchase transaction. It is real, high-stakes, load-bearing work.
And the role of paralegals extends far, far beyond corporate law firms. It is absolutely vital for access to justice. This brings us to our second landmark statutory framework, the Legal Services Authorities Act, 1987. Under this act, India formalized NELSA's Paralegal Volunteer or PLV scheme. This is a formal statutory mechanism designed specifically to train community-level volunteers. These paralegals are deployed to spread legal literacy and assist with legal aid applications in underserved areas. It proves without a doubt that paralegals are fundamental to the legal system's outreach and equity.
And that brings us to Section 5, our comprehensive course recap. We have covered a tremendous amount of rigorous ground today, haven't we? So let's patiently trace our steps to systematize everything we've learned, making sure you walk away with a complete mental map. We began with the legal writing taxonomy, dividing the discipline into academic, practical, judicial, and legislative writing. We then explored the strict characteristics of writing, mastering the IRAC method: issue, rule, application, conclusion. We learned that proper citation is absolutely mandatory, relying on exact style guides like ILEE, the Blue Book, and OSCALA. After that, we marched through the 6-step drafting process, forcefully emphasizing that Step 5, editing and citation checking, is where legal writing either survives or fails. Then we moved to the paralegal's scope, defining them as trained non-lawyers who handle load-bearing work behind the scenes. We anchored their strict professional boundaries in the Advocates Act of 1961, which reserves court representation exclusively for enrolled advocates. And finally, we saw the incredible societal impact of paralegals through the NALSA PLV scheme under the Legal Services Authorities Act of 1987. Just look at the foundation you've just built. You now know the rules, the structures, and the boundaries that uphold the entire legal profession. As we close this explainer, I really want to leave you with one final provocative thought to chew on. How might the exact precision of a single word in a contract, a shall instead of a may, or the meticulous, behind-the-scenes due diligence of one single paralegal entirely shift the outcome of a massive, multi-million-dollar legal dispute. The fundamentals matter because the entirety of the law balances right on top of them. Keep studying, keep analyzing, and I will see you in the next explainer.